You're listening to Soundside. I'm Libby Dankman. In 22 states, people subject to certain domestic violence protection orders must surrender their guns. Washington state has had that requirement since 2014, when lawmakers unanimously voted to strip abusers of their guns. But not all judges here have been enforcing that law. That's because of a 2022 appeals court decision that led many judges and judicial officers to view it as unconstitutional. Now, a new ruling in a separate case may provide more clarity and keep more guns out of the hands of alleged abusers. Maybe. Kelsey Turner is an investigative reporter at InvestigateWest, and she's looked into this very complex issue, and she joins me now. Hi, Kelsey. Thank you for being back on the show.
Hi, yeah, thanks so much for having me.
So we're going to get into the newest ruling that may impact whether people can be forced to turn over their guns in a second. But first, let's go back to the root of all this. Can you explain a little bit more about what the original Washington state law from 2014 was meant to do?
Yeah, so the law in 2014 is meant to protect survivors of domestic violence from gun violence. And the point is that for certain domestic violence protection orders, which is when a person files a petition in court asking for protection from their alleged abuser, for certain orders, that alleged abuser would be required to turn over their firearms and other weapons to law enforcement, and law enforcement would then safekeep those weapons for the time that the restraining order is in place.
And that seems pretty cut and dry up until 2022 with the so-called Flannery decision. What was that, and why did it change things?
The Flannery decision was based around a case with a man named Dwayne Flannery, who was charged in a criminal assault case for assaulting his girlfriend. And he was ordered to surrender his weapons, but he argued that the order to surrender weapons was a violation of his Fourth and Fifth Amendment rights. And so those are his protections against unreasonable search and seizure and self-incrimination. And so he made the argument that because he had been ordered to not possess weapons, that then an order to surrender those weapons would basically be incriminating himself because he's having to surrender and admit to having weapons that he wasn't allowed to possess.
Wait. My mind is sort of having a hard time following those twists and turns. So basically, being ordered to surrender something that he was not supposed to have in the first place would be self-incriminating, even if he actually did have the guns that he was supposed to surrender. This seems like pretzel logic. I'm having a hard time following.
Your confusion is definitely not uncommon. A lot of domestic violence advocates and attorneys argued that this argument was quite a stretch.
That's like if you have stolen goods and the judge orders you to turn the stolen goods in, but then turning them in would be like admitting you had them, and so you would be immune from turning in your stolen good. I'm just like, what were the implications of that if that argument holds for other crimes?
Yeah, exactly. It's kind of a difficult argument to follow. And so the legislature did try to address it as well with the self-incrimination concern, which is pretty much like that by, turning these weapons, you're opening yourself up to possible criminal charges for like unlawful possession of a firearm or something like that. And so the legislature updated their firearm surrender law in 2021 and again in 2023 with new immunity provisions, which would hopefully address these self-incrimination concerns that Flannery had brought up. And so that was the legislature's attempt to pretty much like close this possible Fifth Amendment concern.
So if the appeals court in 2022 did determine that the law was unconstitutional, why were Washington judges split on whether or not to enforce the law?
It was a pretty unclear decision in terms of how it should be applied. And so Flannery's case was a criminal case, first of all, and it was analyzing an outdated version of the law, because, as I said, the law was updated in 2021 and again in 2023. But the Court of Appeals was analyzing the law prior to 2021, which did not include the immunity provisions. And so the Court of Appeals found that in this case, his Fourth and Fifth Amendment rights would be violated if he were ordered to surrender his weapons. But then following that, it became unclear how judges would apply that to civil protection orders.
Hmm.
These civil cases are different in that, like, there's not necessarily criminal charges that are being filed, but it's like a person who, say, like wants protection from their intimate partner and can just petition the court for that, and they can get that order if they can show that that abuse likely occurred. And
But the threshold is different from a criminal case.
yeah, so instead of the beyond a reasonable doubt threshold for a criminal case, the civil cases are showing that it's more likely than not that the abuse occurred. Um, but so judges were not quite sure, what this meant for the constitutionality of the law in cases like that. And so one judge asked the Washington State Administrative Office of the courts to analyze the Flannery decision and basically give an analysis saying what it meant for them, and how to proceed. And so the Administrative Office of the courts came out with this analysis, which analyzed the more recent version of the law and found that the law did violate potentially Fourth and Fifth Amendment rights, and basically advised judges against issuing these orders.
Hmm.
And domestic violence victim advocates and attorneys found that very concerning because after those memos were issued by the Administrative Office of the courts, they said they saw this wave across the state of judges refusing to issue orders to surrender weapons in civil protection order cases. And so judges were crossing out those sections of the court paperwork and just penciling in State v. Flannery or citing Flannery in their decisions to not issue these orders.
Oh, wow.
And it's continuing to happen in some courts.
So there was kind of like a patchwork of enforcement of the ability to get one of these orders to have a accused domestic violence or domestic abuser surrender their guns. Depending on where you were, you could get that order or not. Was there certain areas of the state that were more likely to enforce the law, or certain judges? I mean, did it just depend on the individual, or was it regional?
Yeah, there were some courts like King County, for example, that continued to enforce the law regardless of the Flannery decision. And then other courts like Pierce County Superior Court, for example, and Cowlitz County, Clark County, they all stopped issuing the orders at all. So it was like the entire Superior Court bench was not issuing orders to surrender weapons. And some of those courts have since begun issuing the orders again. And Pierce County is the only court, according to our poll of all superior courts, that's still continuing not to issue the orders. And they're reviewing the newest Court of Appeals case to decide whether or not to issue those orders going forward.
Tell me about the Flannery fix. This is something the state legislature did to try to resolve this confusion, right? So for judges, what did the Flannery fix mean, and why are there still people that are not enforcing this law even after the legislature tweaked it?
The Flannery fix was an attempt to address Flannery's self-incrimination concerns. So it was that Fifth Amendment concern. And so it added immunity provisions, which basically said if you are surrendering a firearm that you are not allowed to have, you would have immunity from criminal prosecution. And some courts analyzed that new version of the law and different case law that was coming out and did decide over time to begin issuing those orders again. And that could happen on like a judge by judge basis. Other courts, like the Pierce County Superior Court, decided that Flannery fix was not enough to address the Fourth and Fifth Amendment concerns, and so they continued to not issue the orders. And so it really did depend on each judge's individual analysis of the law.
Do we know how frequently this was happening across the state and how many cases it applied to? Like how many accused domestic violence offenders have been able to keep their guns that would otherwise have had to surrender them?
Yeah, there's not consistent data that's kept, unfortunately. And one of the issues is that as part of the Flannery fix, the administrative office of the courts is required to collect data on this. And so it would show how many courts are issuing orders to surrender weapons. But the the office still is not doing that, in part because they're saying the data is collected so inconsistently across the courts that it would skew what they're able to collect. And so there's not a way right now, unfortunately, to know how many of these orders are being issued or which courts aren't issuing them on like a systematic basis.
I'm talking with Kelsey Turner, an investigative reporter with InvestigateWest. She's reported on the situation with certain domestic violence protection orders and people who are accused of domestic violence who must surrender their guns if an intimate partner, files to say that they are fearful for their safety. Now, this has been the law in Washington state for more than 10 years, but a 2022 appeals court decision led many judges to stop enforcing this law and to stop issuing these orders for people to surrender their guns. The legislature tried to fix this loophole, but there are still judges that had said they weren't going to enforce. Now, Kelsey, there's been this other decision in a different case by the Court of Appeals, and some say that it's provided more clarity in these cases of accused domestic violence offenders and having to surrender their guns. What was this case and what is the decision?
This was one of the clearest rulings to date on the constitutionality of Washington's firearm surrender law in civil protection order cases. And it involved a man named Brandon Montesi who had a protection order against him by his ex-wife, and he had been ordered to surrender his weapons. And he made the argument, similar to Dwayne Flannery, that the Washington law requiring him to surrender his weapons violated his Fourth and Fifth Amendment rights.
And just to be clear, I just want to really quickly run down the situation with Brandon. This is a person who, had a court order to surrender, but a judge later found that about 13 of his firearms remained unaccounted for. So that included assault rifles, hunting rifles, handguns, a shotgun, and an AR-15. And this is a person whose ex-wife had sought the order, alleging in a court petition that he had swung an axe and threatened to kill her, that she should, quote, think twice before messing with him because he, quote, has a safe full of guns, is what she reported in the petition. So sorry, Kelsey, go ahead.
Yeah, exactly. So the judge had found that he had more weapons that he had not yet surrendered. And instead of surrendering those weapons, he argued that this Washington law violated his Fourth and Fifth Amendment rights. And so, similar to Flannery, it went up to the Court of Appeals, but this time the Court of Appeals ruled that the law does not violate his Fourth and Fifth Amendment rights and that the law is, in fact, constitutional.
So the Court of Appeals is shedding new clarity on what had been a seemingly confusing situation ruling for a lot of people. What has been the effects now of this most recent ruling? Does this mean that the judges in Pierce County, for example, are going to start enforcing these orders to surrender guns?
That is the hope of domestic violence victim advocates and attorneys around the state. Um, this ruling is pretty clear in that it says that the law is constitutional in this civil domestic violence protection order case. And so it should hopefully be what is what could convince judges and judicial officers across the state to begin issuing these orders again. And it seems like it is having an impact so far already. In Cowlitz County Superior Court, for example, they had stopped issuing firearm surrender orders after the Flannery decision. But now, after this recent Montesi decision, which was issued on June 30th, some judicial officers within the Cowlitz County Superior Court did begin issuing these orders again after the Montesi decision. The Pierce County Superior Court is reviewing the decision still and is going to determine how it'll impact the issuing of these orders going forward. So, yeah, victim advocates are hopeful for sure that this decision will convince judges to begin issuing these orders again.
So is this all finally figured out? Has the appeals court had the final say here, and judges, are going to decide that this is constitutional to ask domestic violence offenders to surrender their guns, or accused domestic violence offenders? I mean, is this the end of the story here, Kelsey?
Because it's such a contested issue and there is, the Flannery decision could maybe be interpreted as conflicting with the Montesi decision, and there's other pending cases in the Court of Appeals as well that are also addressing the same issue. It's quite possible that it ends up going up to the Supreme Court in Washington. And in that case, the Supreme Court would make a decision which would clearly be binding to the whole state. And so that's what some advocates and folks involved in these cases are hoping for, that it will eventually go up to the Supreme Court and there will be a decision that's issued that will just clarify this for everyone. And so that those kind of debates between these different courts won't be a problem anymore.
Any timeline on when that could happen?
Right now, Brandon Montesi has asked the Supreme Court to review the decision, and so they're waiting on an answer for whether the Supreme Court will hear it or not, and that will likely take probably like a few weeks or months.
Kelsey, before we go, so the Flannery decision was in 2022, and so there had been several years up until now of some judges across the state refusing to strip abusers or alleged abusers of their guns under the Washington state law. Do we know if that has resulted in anybody being hurt or injured, any intimate partner of somebody with firearms who would have potentially had to surrender that didn't, that then got injured?
Yeah, unfortunately, last year in Clark County, a mother in Vancouver named Carissa Larkin was shot and killed by her ex-fiance, and she had obtained a protection order against her abuser, but the court in Clark County didn't order him to turn in his guns due to the Flannery decision. And at that time, the Clark County Superior Court wasn't issuing orders to surrender weapons at all due to the Flannery decision. And so she was shot and killed. And a few months later, the Superior Court in Clark County did begin issuing the orders again. And they didn't directly relate it to Larkin's death. They said that it was because they reviewed the law again and the case law and decided to again start issuing these orders based on this periodic review that they do. But it did happen a few months after the shooting.
And now we will wait and see how this potentially makes its way up to the state Supreme Court and once and for all have the matter settled, I would expect. Kelsey Turner, really appreciate your reporting for Investigate West on this very important topic. Thank you.
Absolutely. Thanks for having me.
Thanks for listening to Soundside. By the way, this show is only possible because listeners support us. If you are able to give right now, check out the show notes for a link to donate. And don't forget, you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org.